The opinions expressed on the Custody Queen Show are for informational purposes only and are not a substitute for personal, professional legal advice. The persons discussed are fictional and not based on actual clients.
Thought it was love, had kids in between. You can count on us, we're the Custody Queens. Yeah, you can count on us, we're the Custody Queens.
Happy Saturday, everybody. This is Melissa Wheeler. I'm with the Custody Queens, and we have
listener emails today.
Yes. And we're just going to go right into it because we keep running out of time. All right. But we have Melissa Wheeler here with us. She is a custody queen. She works out of our Orange County and also our Corona and Temecula and Riverside office because she serves most of Southern California. And she's been an attorney for almost 10 years. For some of you who may not know her, you can catch her bio and her picture on custodyqueens.com. You can also call her for a consult at 1-800-419-7772. That's 1-800-419-7772. You can also go to custodyqueens.com and fill out a web form, and you will get a call back from the Custody Queens team, and you can request a consultation with Melissa. And I can tell you, you guys are in for a treat. She might not be as quirky as me, but she is a heck of an attorney and a heck of a human, and Sam and I are super grateful to have her.
All right, I'm going to go ahead and jump into the listener emails. Jacob from West LA emailed, "Hello, Custody Queens. I'm a devoted listener of your show and admire your expertise in family law matters. I am a divorced parent and have joint custody of my 2 children aged 10 and 2. Lately, I've been encountering significant challenges in co-parenting with my ex-spouse. Despite our parenting plan, my ex constantly undermines my authority and disregards our agreed-upon arrangements. This situation is causing distress for both me and the children. How can I address these co-parenting challenges effectively? Are there any legal avenues I can explore to enforce our custody agreement and maintain a healthy co-parenting environment? Thank you for your advice."
Hi, Jacob. That was a lot, but we love you too. And I have a million questions, bing, 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 bing.
It depends.
Yeah, I guess, the first question is what are the orders? Is this a verbal agreement? Is this a written agreement? Is this a stipulation? Is this a judgment? You have a 10-year-old and a 2-year-old, so you have still a child of a pretty small age. But I would love to have a conversation with you about your case or with Melissa or Sam. So you can call us at 1-800-419-7772. But I think each of us could provide just a little insight to you. When I have a situation where another parent is constantly disregarding the parenting plan with respect to either drop-offs or pickups or being late or not showing up or changing the place or not having, the backpack or the clothes or whatever it is, my first conversation I have with my client is, okay, I want you to tell me, I want you to put in writing what your concerns are, what is really going on, and I usually start with drafting a letter to the other side to see if it's something that it may be a miscommunication, it may not be deliberate, it may be just some bad luck on traffic the last 3 Fridays, or it may be the exact opposite where that person's just going to blatantly disregard the parenting plan. But depending on that situation, obviously my strategy is going to change just a bit. But it may be that you need to go back to court and tighten up the orders. A lot of times the orders are way too vague and there is too much room for interpretation with respect to the orders. So you may have an order that says the parties will exchange the children on Friday nights. And you may need an order that says the receiving parent shall drop the children off curbside at 7:45, and if more than 20 minutes have passed with no communication, the other parent forfeits their visit. You may need something that is so specific that nobody reading that could interpret it any other way. And it's a strategy that I think us attorneys do when deciding how tight we want the orders. If you have 2 people that co-parent well and there's not a lot of conflict, then we may want to give less details. But then if you have a situation like this, it gets a little sticky. Melissa, what are your thoughts?
My thoughts are, first of all, I want to speak with the potential client, and first let's see what battles we really want to choose, what we want to pick. Because it's easy with a co-parent to get offended when something isn't going your way. But at the end of the day, does it matter that they didn't bring the pajamas when you have a similar pair of pajamas at your house. And I think a lot of people, they kind of find things they want to be upset about.
It's like a power play at times.
Yeah, and I completely understand. It's really frustrating. But at the end of the day, as long as your child is loved and cared for, I think we need to learn to let things roll off our back a little bit more.
In life with general, too. I mean, pick your battles.
Yeah, absolutely. And then I also think an underutilized thing, not in this firm, because Custody Queens always recommends co-parent counseling where it's appropriate. Sometimes,
always.
Yeah, always. But I think people post-judgment or after judgment has been entered in your case, you can meet with the other parent and a co-parent counselor, talk out your issues, hash it out. It's almost like having a day in court, and you can get some feedback. Maybe the other party is being really unreasonable, and they just need to hear it from someone with authority that has experience and say, hey, okay, I'm seeing this problem. Maybe if we had pickup on Saturdays at 8 a.m., a lot of this tension could go away.
And sometimes it may be a legitimate reason or concern. They might have got a new job, or they might have moved a little farther and it takes an extra 20 minutes to get there. But when you have two people that are newly separated, they still get very defensive when the other side is doing something that might not be perfectly aligned. So I always try to start with the premise of what's really going on, what is the real issue with her not complying with all these orders. And some orders may be very, very important, like attending doctor's visits or making sure homework is done. And something else might be like returning the pajamas. Those are two different issues, and I would have a cost-benefit analysis with you, and I would also say, hey, if I check that box for visitation or custody, we are opening up Pandora's box. So is this that important? But a lot of times I think a letter a letter is an often good start to commence solving the issue.
Yeah, and I think that both Melissa and Kristen just gave really good answers for potential solutions. And what I read from this is that what you're currently doing, for whatever reason, maybe partially your fault, partially the other side's fault, but it's not working. And there is sort of a big toolbox that we can dive into of different potential solutions. It might be going to co-parenting counseling and getting a more detailed court order to avoid those conflicts. Maybe the conflicts are because there's a vague order, or maybe you have a parent that's just not listening to a court order anyways because no one's enforced it. And that might take you towards a litigation route, even if you don't necessarily want to go that way. But if what is happening in your life isn't working, we would encourage you to reach out to get those resources to try to figure out what would be best for your situation with your children and your current struggles.
Yeah, and I think oftentimes if the other side is represented, I'm not sure if she is here, but we can set up, a settlement conference call. We can have a four-way, the two attorneys and the two parties, and maybe we can figure out a solution. Like I said, it might be innocent, it might be deliberate, but regardless, it doesn't appear to be working. And you have two different ages with the kids. You have a 10-year-old that's a little bit more self-sufficient and independent, and then you have a 2-year-old that requires much more detailed orders. And I think Sam's right, perfectly right there, is that whatever it is, it ain't working. So let's figure out what our next step is to get more clarity and make it easier for you and then ultimately for her as well. But we love you, Jacob. Thanks for emailing us.
Okay, I have a question. Cynthia from North Hollywood emailed in. Hi, Custody Queens. I'm having a really hard time with my ex. I don't want to give my child the Gardasil vaccine. He is fighting me tooth and nail. Is this something I take to court? Thanks, ladies.
I'm going to let Kristen answer this one.
Yeah, I'm still a little hesitant to answer this. I am not a medical profession. We are not medical professionals here at Custody Queens. What I think all three of us could do is we could have a private conversation with you or anyone else that has this question or concern, and we can provide feedback on what we believe the court may or may not do. But I can tell you the court, they don't want to they don't often want to be put into a position where they have to make orders regarding vaccines or drugs that need to be taken for a child unless they have to. So I think that you need to have some very, very good information on why this is needed, why it is necessary now. I would probably get a couple recommendations from a couple different doctors. Or on the flip side of that, why you do not believe it is necessary or it is needed or in the best interest. But I think this is really more of a conversation that should be had on such an individual basis.
Yeah, and just to add to that, I agree with what Kristen said, but to add to that, this is really a legal custody issue, and a lot of times parents will have joint legal custody, which really requires them to talk together and to make decisions and to agree on those decisions, whether it's health, schooling, education, and figure that out together. And if you can't figure it out together, sometimes you have to go to court, and the court might have to assign a tiebreaker, if you will, or assign a parent the right to legal custody over a particular issue. These are not easy cases. They're often complex, and
they usually require experts to be involved, medical experts.
And reasonable parents may disagree regarding medical care, and you may have doctors on either side recommending different things. I agree with Kristen that you want to at least initially open up a conversation and defer to the medical community and see what the recommendations are for your child. And if you can't come to an agreement with your co-parent at that point, then maybe you seek a second recommendation. And I would encourage that you're thoroughly addressing all those issues before bringing it to court, because, courts don't want to step in and make medical decisions. They really are making decisions regarding your children's legal custody and physical custody, not what is specifically required in that circumstance, because I'm pretty sure I can speak for most judges. They aren't also doctors or practicing doctors, so it wouldn't necessarily be relevant or responsible of them to make those decisions.
And I definitely think it's a good idea to consult with an attorney, like, Custody Queens. It's an issue that has been coming up a lot. Actually, I've had several recent cases.
It came up with COVID too a lot with the vaccine.
Yeah, so with recent events, really pertinent in a lot of cases. But sometimes there is room for compromise and people don't realize it. I have a case where the parents couldn't decide on the early vaccines for their infant, and they actually were able to talk and work it out so that they were spreading out the vaccines.
I use that a lot when you have two people on two different sides.
So sometimes, and that's the benefit of having several attorneys at your disposal, is that we can ask each other, what did you do in this situation, or what would you recommend? And through our experience, we said, hey, I have this one case and we did this, we did that in another case. And sometimes the parties are it's so emotional for them. And that's why having an attorney is great, because we care. We talk about that. We care about this. This is important. But it's less emotional for us, and we have more objectivity. But that also means we may have more solutions and alternatives that you were not able to consider because your feelings may have been hurt on a given occasion. And so,
and it's your kids, and we get that. There's an emotional attachment to that.
Absolutely. Yeah, absolutely. But consult with an attorney and see what we can do to help you work it out.
Yeah, we saw this a lot with the whole 2020 and the COVID thing, and we are not here to discuss with we all probably have different opinions and different positions with respect to vaccines, but that's not what we're here to do. We're here to provide you some objectivity and some advice on what we think the court is likely to do. And the courts don't want to enforce their positions or their beliefs. And you go into a courtroom, you're going to have 10 different judges that are going to completely disagree on what their position is with any vaccine. I can tell you that, co-parenting is co-parenting. It is meeting, it is conferring, and it is consulting with the other parent. And if you can't come to a decision and there's a very serious medical issue, I know we have a handful of these cases where we have children with very, very debilitating illnesses or diseases where one parent will be given the title of the sole legal custodian and will have a higher decision-making power than another parent if there's a disagreement. But I can tell you those orders are not given out lightly. They are usually after multiple hearings and bringing doctors to court and testifying. But educate yourself, have at least one consultation, if not two, and really understand what you're asking the other parent to do, what your goals are, and is this something that you're just wanting to do because it may be trendy or it may be something that's in the news, or is it something that your child needs? Because I think that's one of the biggest questions the court's going to ask. All right, I have a good one. Natalie from Brentwood. Hi, Natalie. Hey, Queens. I caught your show and love you too. I'm not a mom. I'm not even in a relationship, but I'm dating. I heard there's something called a post-nup. What is that? How do I even date knowing this impending doom exists out there? Thank you, ladies. Okay, Natalie, there's not an impending doom. There's a 50-50 chance if you do get married, it may not work. But I think there's a 50-50 chance with pretty much everything in life, right? Not everything is guaranteed to have a positive outcome or result.
Well, I read some statistics somewhere, and I don't know how true it is, but I heard that it was 50% of marriages end in divorce, but not that 50% of people get divorced, because you have repeat offenders.
I can tell you we have repeat offenders. I think that I had spoke with someone one time that had married the same person 3 times and was inquiring about the 3rd divorce from the same person.
Yeah, it happens. And I love love, so don't get me wrong. Keep it up.
But yeah, don't think that a future relationship is destined for doom. You have to have some positivity, Natalie. You have to think, I am this amazing woman. I'm in a great spot in my life. I'm happy with my career. I'm happy with who I am. And I am going to manifest that out into the universe. And I am going to be in a loving and supportive relationship, whether that results in marriage or not. And, manifest that positivity. However, if doom does arise, it's not doom. It's just another day, right, Melissa?
Absolutely. And if you are going into a new marriage, there are options to get a prenup, consult with attorneys.
Do it before you get married.
Before you get married, well before. And actually, I love talking about prenups, and not enough people consider them because they think they're for the uber rich. Or
it's taboo.
Yeah.
You're jinxing the relationship.
Or you don't love the other person, and that's not it at all. It's actually an opportunity to miss out on what causes a lot of divorces. Financial issues and financial disagreements cause a lot of this problem.
You're saving yourself hundreds of thousands of dollars by making it clear what both of you are in agreement before the marriage. I honestly think that if more people had a premarital agreement before getting married, I think that would actually lessen the amount of divorce, because I think they would know going into the relationship exactly what both parties' financial situations are.
And remember, you have to agree to the contract, right? So the advantage of entering into a prenup versus a postnup, meaning after you're married, is that you have the opportunity to have your own attorney, advising you regarding those contractual rights. So
your disclosures.
So again, it's like, I understand that in society we often hear that one party's extremely rich, the other party isn't, and so sign this or I'm not marrying you and you don't love me, baby. But the real essence of a prenup is that you are both contracting for your benefit. So you should both have an attorney, and there's very specific requirements that typically need to be met to satisfy a prenuptial agreement. And so we would encourage that, especially if you're concerned that after you're getting married that there would be a need for a postnuptial agreement. If there is a need for a postnuptial agreement, there was a need for a prenuptial agreement and nobody did anything. So we would encourage you to start there.
They love talking about postnups on TV shows for some reason. I see it all the time in legal shows, and it seems like it's so easy to get. I can tell you that postnuptial agreements, which post mean that they are come to, that the agreement is allegedly come to after you're married, it is absolutely deterred by the court. I can tell you that if the purpose of a postnup is to punish maybe a cheating spouse, like I will stay in this marriage if you decide to give me X, Y, and Z. I'm not gonna give you a second chance if you don't sign this agreement that awards me, some assets or some dollars. If the purpose of that postnuptial agreement is to serve as a punishment, I can tell you that most likely that postnuptial agreement is not going to be deemed valid. If it is unconscionable, like I can't even believe that somebody would agree to this, I think that's a very good defense to that argument. But I can tell you most judges, they don't like them. They don't deem them valid.
Yeah, the issue of prenups and postnups is a complex one, and it doesn't mean that you shouldn't get one. There are circumstances to get a postnup, but in either event, my pro tip, and I think Custody Queen's pro tip would be, do not sign anything without talking to an attorney ever. Just don't do it. Understand your rights, understand what rights you're waiving, what rights you are trying to obtain, and make sure that you have adequate legal representation. With the example of a prenup, although you don't have an absolute requirement that both parties have an attorney, there are additional documents that have to be signed if both parties don't have an attorney. I'm going to tell you right now, whether you want someone to sign a prenup or you are signing a prenup, you want everyone, and it's in everyone's best interest for both parties to have an attorney. That is
Absolutely.
Whether or not you want someone to sign the prenup that you had your attorney draft or not. So it's a complex issue. There's a lot of nuances to it that Kristen touched on. And this is a situation where you do want an attorney consult. And we would encourage you to reach out. If you guys have questions for the Custody Queens, you can call us at 1-800-419-7772. That's 1-800-419-7772.
And I just wanted to clarify one more thing that I may have said. Anybody can do a postnuptial agreement. Any attorney you talk to, yeah, I'll do it for $10,000. Yeah, this is super easy, we got it done. But the issue is whether or not the court will deem that agreement valid. So anybody can do it. A lot of attorneys will take them, but only the good ones are going to tell you that the likelihood of that agreement being enforceable is probably not very high. All right, we're almost running out of time, but I think we can get 2 more in if we're really quick, but I want to give one to you guys. Okay, Callie from Los Angeles. Hey ladies, I am a new attorney. I just love your show. I was wondering, has there ever been a case where you refused to represent the client? Thanks, Kristen and Sam.
Yes.
1,000%.
Absolutely. Yeah.
Yes, Kristen preaches about this a lot. It's a two-way street, right? We absolutely want to be the right fit for you. Sometimes we aren't, and we can't change who we are to be your attorney. I operate a certain way. I'm not a one-size-fits-all. Some people love me. Some people maybe want a different attorney, and that's okay, but it goes both ways. And so for me, it is very important that I believe in my clients. I believe in their case, that their goals and expectations are reasonable. Part of that is having a back and forth and seeing if we're on the same page. But certainly, I think everyone agrees with such an important decision. It is very, very important that you trust your attorney and that your attorney trusts you. It goes both ways.
Absolutely. And I've definitely declined or found ways to kindly encourage the client to hire somebody else or consult with another attorney if they're not being reasonable, if they are trying to punish the other side, I will tell you, reputation in the legal field is everything. Our reputation in the various counties, we see the same judges every day. We see the same opposing counsel all the time. Is there going to be a position I have to take that I cannot make with a straight face, or is going to come off as very offensive and it challenges my values? Probably not a good fit.
Yeah, no, I think they said it right. I can say earlier in my career, I was more likely to take cases that I had a hard time seeing the big picture, or the client and I may not have been a good personality fit, but the longer I do this, the more confident I get in my own skin and my skills and the team that we have. There are some cases that are just not worth it to take, no matter how much that person is willing to pay. And I've learned a couple hard lessons with that. I've also learned that representing good friends and family never ends well. It is often the people that you are doing a favor for, or that you're helping out in a pinch, or you're trying to save money, where they end up being the most conflict. And so I have really learned to say, you know what, I can't wrap my head around this, or I don't think that we value the same things. I don't have to agree with your position. I don't have to believe the same things, but there has to be, for me, there has to be some sort of respect and a connection between the two of us, because we're going to be on this journey together. And if I'm not passionate about your case, you shouldn't be hiring me, because that comes through with attorneys. When I go to court and I see attorneys that read the file in the car on the way over there, or they're calling their name, you know, is Diana here? Like in the hallway, that tells me that attorney, A, didn't prepare, and B, that they don't have any personal investment in that case. And while that is your life and your case, I think we all show a lot of pride in what we do. But yeah, I'm with Melissa, and I can tell you that sometimes I see it right away in the consult. I might not be as kind as Melissa said she is on turning down clients. I might just say straight up, we are not the right fit. But there are other times where I might have been your attorney for a year and a half and we've seen eye to eye, and then I start feeling and getting pushback from you on the littlest things. But my biggest deal breaker is people that intentionally alienate children, that try to keep the children away from the other parent just because that's what they want to do and because they hate that person. That for me is a professional deal breaker, because I think that every child needs as many parents in their life as possible. But if you're not going to listen to my direction, then why are you paying for us? We can make decisions together, but if we're not on the same page, I have no problem firing. I actually do it fairly consistently, and sometimes it happens in 6 months, sometimes it happens in 6 years. But at some point, I think attorneys, we get burnout too. We get burnout, and we're no longer the right fit. It doesn't mean I dislike you as a person, it just means I'm not the right attorney for you. And Sam's laughing because she's definitely heard me do this a few times.
Oh, yeah. Yeah.
And the funny thing is I'm usually friendly or friends with most of them after the fact. It just came down to the point that we weren't on the same page legally anymore. Because the whole mission behind Custody Queens is that we have the law and we have family. And our goal is to unite the two to allow you guys to move on with your life and to be in this relationship together and trust the process. Trust me, I trust you, we trust the process. All right, we have a minute and a half, girls. It's gonna be super quick. Cole from Anaheim emailed in, I am a divorced parent with sole custody of my 8-year-old daughter. Due to a recent job offer, I am considering relocating to another state. However, my ex-spouse, who has visitation rights, is strongly opposed to our daughter moving away. What are my rights as the custodial parent in this situation? Can I legally relocate with my daughter? Thank you, Custody Queens. I love you guys. All right, Sam, you're the move away expert, and then I'm gonna let you and Melissa wrap this one up.
Well, I'll keep it short and sweet. If you can't come to an agreement, then you're going to have to go to the court and request the ability to be able to move. You have a stronger presumption if you are the custodial parent. There's a Family Code Section 7501. You don't need to know that, but you just need to know you do have a stronger presumption subject to the court finding that it's detrimental to move, but you still got to ask permission, so you have to come to an agreement or have a court order.
And absolutely make sure that you're talking to an attorney about this. These are some of the most highly litigated cases. You need to act quickly. By the time you've decided to move, you needed to file yesterday.
That's exactly what my last point was going to be. These are often like a 1 to 2 year process. Do not wait until you actually get a job offer. If you are considering it 6 months prior, that's where you start getting the wheels in motion. That's where you have the consult, you get the RFO for the request for move away. A psychological evaluation is often done in these cases, where a psychologist will interview the children, mom and dad, any collateral third-party contacts, and they will come up with a recommendation on where the child should live, either with the parent relocating or if they should stay here with the other parent. And the closer you are to a true 50-50 time visitation schedule, the less likely the court is going to be inclined. But we've had a lot of clients that have been very successful on both sides of this, but it is a process. Do not wait until school starts in a month or your job offer, you have to be there next week. This is a 1.5 to 2 year process. And that's a wrap. Look at, we did that, and we are just getting so good. I'm so happy for all of us. And we love spending our mornings with you guys. And we hope that you are telling your friends and family about our show. We hope that you are calling us at 1-800-419-7772. That's 1-800-419-7772. Thank you for spending your Saturday with us and welcoming Melissa into the CQ family. And we look forward to seeing you guys next Saturday and every Saturday. And make sure you are following following all three of us on Instagram, and we look forward to spending more time with you.
And remember,
let love rule.